Wharton, in his law lexicon, defines prerogative writs as processes issued upon extraordinary occasion and proper cause shown. Lord Salisbury, in his Law of England, calls them extraordinary remedies which are issued upon cause shown in cases where the ordinary legal remedies are inapplicable or inadequate. Writs are a feature of the Anglo-American system of jurisprudence. The word writ has been used in the sense of a written document under the seal of the court issued to a person or authority, including government in appropriate cases, commanding them or any of them to do or forbear from doing some act. Hidayatullah Jain Bhilal versus Additional Deputy Commissioner Akola, 1953, Nagpur 19. There are two kinds of writs, the prerogative writs and the original or judica writs. The original or judicial writs commence between party and the issue of course. The prerogative writs are exceptional processes which issue only upon proper cause shown. As the prefix prerogative suggests, they do not originate from the enacted or common law but issue from the sovereign rights of the king as the fountainhead of justice. The prerogative writs are ancient remedial process of an extraordinary nature which have from the earliest time issued from the court of king's bench in which the sovereign was always present in compensation of law. The jurisdiction to issue such writs was later on extended to the High Court of Justice under the Supreme Court of Judicature Act 1925 in England. What writs can be issued? Under Article 32 and 226 of the Constitution of India confers upon the Supreme Court and the High Courts respectively the power to issue direction, order or writs, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of the fundamental rights. And in case of Fertilizer Corporation, Kamgar Union versus Fertilizer Corporation, AIR 1931 SC 344. The importance of Article 32 has been explained in the following words. Jurisdiction conferred on Supreme Court has been characterized as an important integral part of the basic structure of the Constitution, as it is meaningless to confer fundamental rights without providing any effective machinery and remedy for their enforcement if and when they are violated. India being a republic and there is no such thing as the prerogative of the crown, the Constitution of India nevertheless arms the Supreme Court and the High Courts with powers to issue exceptional processes which may not call prerogative writs but which are of the same nature and scope as such writs. That is, which are, in the words of Lord Hansbury, extraordinary remedies intended to be applied in exceptional cases in which the ordinary legal remedies are inadequate. Having regard to the language of Article 32 and 226, the power of the Supreme Court and the High Court are not confined to the issue of this or such writs, but cover a wider field, and they may issue any other order, direction, or writs whichever be deemed appropriate by them. In Rashid Ahmad versus Municipal Board, Kairana, EIR 1950, SC 163, the Supreme Court said the power given to the court under Article 32 are much wider, not confined to the issue of five prerogative writs only. In Chiranji Lal versus Union of India, 1951, Mukherjee, Justice of the Supreme Court, observed that the Article 32 of the Constitution gives us very wide discretion in the matter of framing our rates to suit the exigencies of particular cases. At the same time, the right to get the relief under Article 32 is guaranteed under Article 32 Clause 1, whereas Article 226 does not carry such rights. The authority to the Supreme Court extends to the whole of the territory of India, and while that of the High Court is limited to its territorial jurisdiction of the state. Habeas corpus, the literal meaning of habeas corpus, you may have the body. The writ of habeas corpus is a writ for securing the liberty of person where such liberty is wrongfully taken away. It is an effective means of immediate release from unlawful detention, whether in person or in private custody. The writ consists of a command from the court of the production of the person detained or imprisoned, and though this writ, the court make an inquiry into the cause of imprisonment, and there is no legal jurisdiction for detention. The person detained is ordered to be released. Who can apply an application for habeas corpus can be made by either of the prisoner himself or by any other person on his behalf. Supreme Court in Sunil Batra versus Delhi Administration 1980 case observed that the technicalities and the legal necessities are no impediments, and the most entertaining event an informal communication as a proceeding for habeas corpus. The Supreme Court has now considerably widened the scope of locus standi. Now, any person who is substantially interested in the affairs of any class of person who, by reason of poverty or any other cause, are unable to approach the court for the issue of the writ. When the writ can be issued, the application of the person for whom the application is made must be in custody. Number 2. The application of habeas corpus ordinarily should be by the husband or wife or father or son of the detainee. Sila versus State of Maharashtra. 1982. All the formalities relating to arrest and detention are based on mala fides. Example, long delay in communication of grounds of arrest. The order of arrest must be defective in substance. Vague and indefinite grounds of detention are also be one of the good grounds for getting a writ of habeas corpus issued. Order of detention is tainted with irregularity. The writ of habeas corpus cannot be issued in the following condition. Number 1, if the application is made to the High Court and the place where the person is detained that is outside the jurisdiction limits of the High Court. When during the pendency of writ petition the person in question is released. Number 3, when detention is in execution of any sentence on indictment of a criminal charge. When a person is detained under a preventive detention law. Mandamus. Lord Halsbury in his Law of England describes the writ of mandamus as follows. The writ of mandamus is what? The writ of mandamus is a high prerogative writ of a most extensive remedial nature and is in form of a command issuing from the High Court of Justice directed to any person, corporation or inferior court requiring him or them to do some particular things is therein specified which appertains to his or their office and is in the nature of public duty. In mandamus, there may be command to do a particular thing or to abstain from doing a particular thing. That is, the command may be either positive or negative. It lies in in respect of a legal right or a legal duty, but not in respect of rights and duties of a purely moral character. Where there is no duty but only a power to do a thing, mandamus will not lie to enforce the exercise of the power unless the power is coupled with a duty to exercise it. Lord Mansfield says whenever there is a right to execute an office, perform a service, or exercise a franchise, more especially, it is it if it be in a matter of public concern or attended with profit, and a person is kept out of possession or dispossessed of such right, and has no other specific legal remedy, the court ought to assist by a mandamus up to reasons of justice as the writ expenses, and upon reason of public policy to preserve peace, order, and good government. When the writ will be granted, the writ of mandamus is granted to a person whose right have been infringed if the following conditions are fulfilled. The petitioner has a legal right, the legal right has been violated, and the reason of violation was the non-performance of the corresponding duty by the public authority. That the petitioner has demanded the performance of that legal duty by that public authority and the authority has refused to act. The duty sought to be enforced must be of public nature, that is created by some statute and not of a private nature. Not of a private nature. When it will not lie. The writ of mandamus do not lie in the following circumstances: when the duty is to do ministerial work, when the duty is merely discretionary to enforce contractual obligation. In Punjab Engineering College versus Sanjay Gulati 1983 case, the Supreme Court held that the college authorities were under a mandatory duty to admit students to educational institutions. No student can be denied admission on extraneous grounds by overlooking norms set by rules and regulations. If it is done, the Supreme Court can order the authority concerned to set to wrong right by admitting the student left out wrongly. Prohibition. A writ of prohibition is a judicial writ issued by a court of superior jurisdiction directing an inferior court for the purpose of preventing the inferior court from usurping a jurisdiction with which it is not legally vested and to compel courts entrusted with judicial duties to keep within the limits of their jurisdiction. Dost Muhammad Khan versus Hyderabad Government 1953. Thus, the writ of prohibition lies only against judicial and quasi-judicial authorities. A.C. Gobert versus High Court, Allahabad, 1959. Thus, prohibition may be issued for both excess of jurisdiction and absence of jurisdiction, violation of natural justice, fraud, contravention of the law of the land to a judicial or quasi-judicial body which is inferior than the issuing court. Existence of an alternative remedy is no bar to the issue of the prohibition. Distinction between prohibition and certiorari. According to decision in Hari Vishnu versus Ahmad Ishaq, 1955, there are following points of distinction between prohibition and certiorari. So, what are those differences? Certiorari is substantially concerned with jurisdictional defect. Certiorari concerned with jurisdictional defect, while prohibition wholly concerned with matter of jurisdictional defect. The first effect of interference start working at different stage in these two writs. Interference through the writ of certiorari takes place after the order has been passed by the court or tribunal. But in case of prohibition, interference comes into operation only when the inferior court or tribunal have proceeding pending before it. Have proceeding pending before it, then what what kind of writ can be issued? Certiorari can be issued. Certiorari when the effect of interference certiorari is when the order passed. By prohibition to prohibit the proceeding which is pending before it, before the inferior court. The writ of prohibition is meant to prohibit a court or tribunal from exercising its jurisdiction where it has either exceeded from granted one or has no jurisdiction. But in case of certiorari, the writ is asked for granting an order quashed as it was made in lack of jurisdiction. Certiorari is a command or an order by the superior court to inferior court or tribunal to transmit a record or cause or matter pending before them to the superior court not to proceed with the case. Certiorari means not to proceed with the case. Okay, prohibition means certiorari means already decided case, na. Matter cause of matter pending before them to the superior court not to proceed with the case. Prohibition and certiorari. प्रोहिबिशन का मतलब क्या है? रिट ऑफ प्रोहिबिशन एक जुडिशियल रिट है जो कि कोर्ट ने सुपीरियर जुरिस्डिक्शन वाले कोर्ट ने इशू करा है इंफीरियर कोर्ट को डायरेक्ट करते हुए कि प्रिवेंट करने के लिए इंफीरियर कोर्ट को उसर्प करने के लिए जुरिस्डिक्शन से जिसके लिए वो लीगली जिसको वेस्टेड नहीं है, जो जुरिस्डिक्शन उसके पास नहीं है, या कंपल करने के लिए कोर्ट्स को कि इंटरेस्ट जिसको इंटरेस्ट किया गया है जुडिशियल ड्यूटी के लिए ड्यूटी के साथ, ताकि वो अपने जुरिस्डिक्शन के लिमिट में रहे. ठीक है, तो प्रोहिबिशन हो गया. तो ये सर्चुलरी क्या है? कमांड है और ऑर्डर है सुपीरियर कोर्ट का इन्फीरियर कोर्ट का ट्रिब्यूनल को कि एक रिकॉर्ड भेजो, कॉज भेजो, मैटर भेजो जो पेंडिंग है उसके पास में सुपीरियर कोर्ट को कि प्रोसीड ना करे केस के साथ जो कि उसके जुरिस्डिक्शन में नहीं है, और क्वाश करे कोई ऑर्डर जो भी किया है ऐसे कोर्ट ने ऐसे केस में. If the order of inferior court is found to be without jurisdiction or against the principle of natural justice, it will be quashed. In Champawal versus Commissioner of Income Tax 1970, it was held that a position for writ of certiorari may lie to High Court, where the order is on the face of it erroneous or raise question of jurisdiction of infringement of fundamental right of the petitioner. Who may apply? Any person whose legal right has been violated can apply for the issue of this writ. Any person on behalf of a group of person or society or person at large. Grounds on which a writ is issued. Following condition must be fulfilled before a writ of certiorari be issued. The act, order or judgment in respect of which the writ is sought to be issued should be act, order or judgment of an inferior court or statutory body exercising judicial or quasi-judicial function. Such court or body must have acted in absence or in excess of the jurisdiction vested in it the principle of natural justice so as to render such act, order or judgment invalid when there is an error apparent on the face of record. In case of Gujarat Steel Tubes versus Mazdoor Sabha 1980, Supreme Court explained the meaning of the phrase error apparent on the face of the record. It was held that every order cannot be corrected merely because it is wrong. It can be caused only if it is vitiated by the fundamental flaw of gross miscarriage of justice, absence of legal evidence, perverse misleading of facts, serious errors of law on the face of the order, jurisdictional failure, and the like. The Harbans Lal versus Jagmohan Saram, 1986, it has been held that the writ of certiorari is issued only if the order of the inferior tribunal or subordinate court suffers from error of jurisdiction or from breach of principle of natural justice or if vitiated by apparent error of law. The ground mentioned above for questioning the orders are self-explanatory of the term error on the face of record. Quo warranto. By issuing the writ of quo warranto, the court seeks from the person to whom it is issued information as to the warrant or authority by which the said person supports his right to an office, franchise, or liberty. It lies against a person who claims or usurps an office, franchise, or liberty with respect to which information is sought, so that such person's right to the same may be determined in the light of the authority of warranto cited by such person in support thereof. The writ of quo warranto cannot be issued unless the defendant is in actual possession of the office and exercises the office. R.V. Green Q 2Q bit 460. The holding of a liberty as a matter of fact is a condition precedent to the determination of a right to the same and the calling up of information with regard to it. A motion of a writ of quo warranto can be made at instance of a private person, although he is not personally aggrieved or interested in the matter. The motion does not require the intervention of the government or any public authority. This type of writ is a discretionary remedy and is not issued as a matter of course, but only after the conduct and motive of the petitioner is inquired. D.C. Jain versus University of Jodhpur, 1977. When the writ can be issued. The writ can be issued when there is a illegal usurpation of public office by an unauthorized person. The public office is of substantive nature. The remedy under this writ can only be granted when the office in question is of public nature and not of private nature. Public office is that which is created by statute of constitution, and the duties to be performed are of public nature, and the office must be one which is permanent in the sense of not being terminable at pleasure. The person proceed against has been in actual possession and is the user of particular office in question.